I received a letter from the bank's lawyer. Am I in foreclosure? I'm Steve Kramer. I'm a Florida foreclosure lawyer. Now, generally in a foreclosure lawsuit, the lawsuit is actually filed in circuit court. And when it's filed, it has to be served on whoever's sued, and that would be you generally. And service means that somebody comes and they knock on your door, and they're an authorized service processor, and they hand you a copy of the lawsuit, and they tell you that you've been served. And in that lawsuit that they hand you will be a summons on top of it, and then behind it will be a complaint, and then a lis pendens. Now that summons on top will generally say you've been sued in whatever circuit court, and you have so many days to respond, and that's usually going to be 20 days. And if you do respond, then you've gone ahead and you've defended your lawsuit. And if you don't respond, you can be defaulted, which means you automatically lose. Now, if that process server comes over and they knock on your door and you don't answer, well, they're supposed to try again. And they're supposed to make a legitimate, good faith try to serve you. But if you're out of town for a month, or you're hiding behind that door because you really don't want to get served, or you're avoiding service, or you work odd hours and they can't get you served, then the plaintiff still wants to get relief. And the way they do that is generally they would do a notice of the action. They would mail you, and usually by certified mail, a copy of the lawsuit and putting on notice by mail that you've been sued. And the other thing that they would do is they would publish notice of the lawsuit in the local paper. And if they do those items, then they can go ahead and say that they've constructively served you. And the difference is when you're actually served, the process server goes ahead and hands you the lawsuit. When you're constructively served, well, you were mailed a copy of the suit, it was published in the paper, you've been put on notice, it's presumed that you know about the lawsuit. Now, if you've been constructively served and you don't respond because you don't know about it, or you choose not to, then you can be defaulted, which means you automatically lose. And the answer to the question is, I got a letter from the bank's lawyer. Am I in foreclosure? Well, the answer is you need to be careful. You need to look at that letter to be sure, because you could have been served by constructive service and there could be an active lawsuit pending. And the way you make that determination is you're going to look at that letter. You're going to see if it's actually a court document. And if it's a court document, it'll have a little caption at the top. It'll say, for example, in the 18th Circuit of the state of Florida, in and for Seminole County, Florida. All right, and then below it'll say Deutsche National Bank versus your name. And I'll have a little case number there, and I'll have a name for whatever that pleading or document is. And if you see that, that's a pretty good indication that you are in foreclosure. And if you're not sure, or there's any doubt in your mind, the best thing that you can ever do is pick up the phone and call somebody like me, because I've seen thousands and thousands of these documents. I know exactly what they look like, and I can give you a very easy answer that may be able to put your mind at ease. And if not, get us in a position where we can go ahead and do some damage repair and get your case defended properly. I'm telling you this because I deal with this all the time. I've dealt with a lot of people in your position, and I'm glad to help you. So if you have any questions, go ahead and give me a call. I'd love to talk with you. I appreciate you watching. I'm Steve Kramer.